Hey, Facebook Live, Sean Yesner here with Yesner Law and the Crushing Debt podcast. And so I wanted to record a quick episode here before I take off for the afternoon. So again, as with all my other Facebook Live videos, after I'm done recording the episode itself, I'll stick around. And if you guys have any questions, either about what I talk about in the episode or anything that I talk about, let me know. I'll stick around to answer your questions on Facebook Live. But today's topic is all going to be on discovery, and I'll explain a little bit more what that is and why I wanted that to be today's topic on the podcast. So with that, let me start up the podcast episode. On this week's episode of the Crushing Debt podcast, what is discovery? So welcome back to this week's episode of the Crushing Debt podcast. My name is Sean Yesner with Yesner Law, and I wanted to let you know real quick before we get started here on the show, I wanted to talk about Elliott Wealth Management Services, who is our sponsor for the Crushing Debt podcast. So for my listeners, they are offering a free 15-minute life insurance checkup. You can go to their website, which is elliottwealth.com, and hit the life button at the top of the page. So if you don't have life insurance, it's really something you need to look into. It can help you get rid of debt. It can help your heirs get rid of debt. It can help you to invest in real estate. It's something you want to look into if you've changed your marital status, if you have minor kids, or if you own your own business. Basically, if you have anyone who relies on your income. If you do have life insurance, you may want to go to Elliott Wealth Management Services and do their free checkup to see if you have the right amount of protection. I spoke with Chris Calandra the other day and realized that I could get more life insurance for cheaper. So I definitely suggest you go to elliottwealth.com. There's a life insurance checkup link there that you can click on. You can get your free appointment to go check out their life insurance services and what they offer. But aside from that, I wanted to get to today's topic, which is discovery, as I said in the introduction. And so what is discovery? Discovery is the compulsory disclosure of relevant documents. If you want to search the word discovery on Google and see what it says from a legal perspective, the compulsory disclosure of relevant documents. And part of the reason that I say, what is discovery is the way I explain it to clients is it's making sure that we know what the facts are in a particular case. In other words, when you watch those law dramas on TV or in the movies and, one side surprises the other side, are you lying to me then or are you lying to me now kind of stuff? Well, that's all through discovery. So discovery is where the other side wants you to cement your arguments. They want you to explain your legal theories. They want you to explain why you think, how you think about your theories of the case. And so that way, if you do deviate from those opinions, they can call you on it. You can't say one thing in discovery and then say something different when you're there on the stand. So one issue about discovery is that it must lead to admissible evidence. The discovery itself doesn't have to always come in terms of the lawsuit, but it does need to lead to admissible evidence. And so the discovery is really an art form. It's something to be crafted to make sure that, again, you are cementing the other side's story so they cannot deviate from it. So what are the different types of discovery? Actually, you know what? Before I get there, I want to tell you why discovery is such an important issue today. So today I was actually deposed. So I was an attorney, and I'm not going to get into the details because the lawsuit is pending, but I was an attorney in a foreclosure lawsuit. I was representing the lender in the foreclosure lawsuit. Now, the lender was a trust, and the trustee of the trust was, let's call him Dad. And younger brother was the one that first brought the case to me, and I assisted with the lawsuit. And then at some point, older brother took over the lawsuit, took over guiding me in terms of how the foreclosure was going to be prosecuted. Older brother took over. And at some point, there was a dispute between older brother and younger brother, and they started fighting about it. And so today was my deposition. And I had to give testimony about what I did for the trust and what I did for Dad and what I did for the older brother and what I did for the younger brother and all that kind of stuff. And so let me tell you, from from my perspective, it was interesting being on the side of the one being interviewed. Ironically, tomorrow, I am actually taking the deposition of a witness in one of my cases. But I did get a compliment from the court reporter who said I did a really good job in giving my testimony. And so I'm kind of proud of that. And having been through a couple of depositions, I know what the court reporters go through. So when I said a word that was a little confusing, like someone's name, I would spell it out for her, or I would make sure that I was slowing down. Not only for me to make sure I collected my thoughts, but also to slow down to make sure that she could record my testimony correctly. And so there is some interesting things that go on with deposition. So a deposition is the process of giving sworn evidence. One thing to take from that is that it is under oath. And so if you lie on your deposition, you can be charged with perjury. The one interesting thing I will say about depositions is you want to make sure that you tell the truth. And so there were a lot of times today where they would ask me a question and I didn't know the answer. And so I said, I don't know. I don't remember. I don't recall. I wasn't thinking about that at the time. So they were asking me what, this one thought or that one thought. And I said, look, I really wasn't thinking that this could devolve into a lawsuit. At the time I was representing the trust for dad or for one brother or the other. And so I really wasn't considering that I'd be sitting here at a table giving my deposition however many months later. So I didn't really think about it. I don't know the answer. That's an acceptable answer. If you don't understand the person that's asking the question, you can ask them, please repeat your question. I didn't understand it. There's a lot of things. If you have to get up and go to the restroom, you can get up and go to the restroom. You don't necessarily have to sit there for the entire time of the deposition and be grilled and be asked questions by the people asking Now, some depositions have gotten pretty out of control. They've gotten pretty contentious, and it happens. I mean, this case was not one of those. I was a neutral witness, I think, to both sides, and telling the truth. But, again, if you tell the truth, you don't really have to focus on remembering what happened. You're just telling the truth. There are objections at depositions. So a lot of times I might object or somebody else might object. But here's the interesting thing. The deposition is designed to lead to admissible evidence. So once the question is asked, unless it's something prohibited, like an attorney-client privilege comment, you have to answer the question that's asked. Now, then what happens is the transcript goes up to the judge, and when one side wants to use that testimony that has been objected to by the other side, the judge will decide if the objection applies and if that evidence, if that testimony, if that deposition testimony comes in or not. And so you want to tell the truth in a deposition. I wouldn't really be overly nervous about it. Now, having gone through the process myself, I just told what I thought was the truth. The person asking, the attorneys asking the questions, I think they knew I was an attorney. They knew I had taken depositions. They were very professional in the way that they asked me their questions. I hope that they feel I was professional in the way that I answered the questions. But going through that deposition today got me thinking about the process of discovery and what is it and how does it work and all that kind of stuff. So in addition to a deposition, one other tool that people use for discovery is called a request for admissions. And it is exactly what it sounds like. It's a list of facts that you have to admit that they are true or deny that they're true. And that's all it is. Now, the interesting thing about a request for admissions, at least under Florida rules of civil procedure, if you don't answer the request for admissions, they are deemed to be true, all of them. So when you're drafting requests for admissions, you want to draft them very specifically in such a way that if they don't get answered, they're all deemed to be true and they will make your case for you. Now, a lot of times the way that the request for admissions are drafted will be set up to make someone's case. And so you want to avoid compound questions in a request for admission, because if one part is true and the other part is false, I think you can deny that the whole thing is true because one part of it is false. So you want to avoid those types of questions. You want to, again, avoid lying. And so if there's an admission that they want you to admit or deny, but it's the truth, then you should admit it. If there's a way to challenge that request for admissions, then you can deny it. Just make sure that you're always telling the truth. And I think the purpose of the request for admissions, at least in my experience, is to narrow down those facts that are in dispute. If I get 20 different requests for admission, not 20 documents, but 20 questions within the request for admissions, and I admit to 10 of them and I deny 10 of them, then fine. We know half the facts are agreed to and half the facts we're going to have to prove up at the trial. And so I think the request for admissions is used to narrow down the facts. The next type of discovery you'll get to is a request for production. That is a request for production of documents. So again, if you have the document, if the document exists, then you should produce the document. Now, I've said many, many times here on the podcast, in my blog, whatever, if you've got the hand, go ahead and show it. And so if the other side asks me for certain documents within a request for production, but those documents support my side, obviously I'm going to send all of those documents. I'm going to highlight where they are. I'm going to highlight the significance of them. If you've got the hand, show it. This ain't poker. So but the request for production is going to lead to documents. Now, if you leave out documents in your request for production, I think the other side can argue that you should not be allowed to admit those documents when you finally go to trial. I had a client once, we were suing under the Fair Debt Collection Practices Act. The client told me about all the different medical bills that she had, and I asked her to support those claims with medical bills so that I could try to argue that those damages would be included under the Fair Debt Collection Practices Act, and we could sue the creditor for those medical bills. Now, I don't know that I ultimately would have prevailed in front of the judge. I don't know that those types of medical bills, unless they are directly relatable to the debt collection practices, I don't think those medical bills would come in as damages. But the client never gave me the medical bills. She never gave me the documents that I need. The other side had asked for them in discovery. So when we went up in front of the judge for the trial, the judge said, well, if you didn't disclose those documents, you don't get to rely on them. Now, the client was mad, but I had in my file enough warnings to the client that, hey, look, if you've got medical bills related to this debt collector, I need those immediately so I can share them with the other side, so I can prove up our case so that we can do that kind of stuff. A lot of times I'll talk to clients about, it's not about what we think happened. It's not about even sometimes the truth. It's about what we can prove. And the way that we prove that is the other side will ask us to produce documents in discovery, and we have to produce those documents to them. The last kind of discovery is called interrogatories. And again, interrogatories are exactly what they sound like. They're interrogation type questions, but they're written. So what the interrogatories will say is, you claimed that your second affirmative defense was, payment and satisfaction. And so explain to us what that means. Why did you include that? Or any documents that are produced in production, please explain in a narrative form the relevance of those documents. Or maybe there's discovery, there's a deposition, and the plaintiff wants a little bit more background about what was said in the deposition. They may send out an interrogatory that says, explain to us ABC. Explain to us the relevance of your affirmative defenses. Explain to us how your affirmative defenses apply. Or if I'm on the borrower side, send interrogatories. Explain how the process is of tracking your original loan documents, bank. Or give us an interrogatory about how, explain to us how this loan was transferred from the ultimate originator of the loan to now where it sits at your bank. And so again, we're trying to get written documents. We're trying to get the other side to put in writing their theory of the case so that we know what we have to argue about. I think one of the biggest complaints that I get from clients is, why do I have to answer all this stuff? Now, we will do a lot of the answering for them, although we do have to have them review it to make sure that it is all correct and that they have approved of everything, and maybe they'll give us the answers and we'll put it in some legal format so that it complies with whatever request for admission, production, interrogatory, whatever. But the evidence that we produce is from the client. And so a lot of the clients will get confused about, why do I have to present this stuff? Well, if you don't, there could be consequences. Like I said, there is a consequence that you might not be able to introduce certain evidence into the court if you don't produce it in a request for production. You may be barred from arguing something if you admitted it in a request for admissions. You may be unwilling to change your testimony, and that's where a lot of the attorneys get, well, are you lying to me then, or are you lying to me now? As if you counter something you've said in a deposition, you may have trouble going back and trying to change that testimony. Now, one interesting thing about a deposition, at the end of the deposition, the court reporter will ask you if you want to read or waive. Now, typically what that means is that you can read the deposition to see if you've said something false. Now, I don't think you can change the relevance of your testimony. And so if I said, no, I didn't, I didn't murder that person, and I said that in the deposition, and I want to change it to, I was acting in self-defense, something like that. I did shoot her, but I was acting in self-defense. I don't know that that could be changed by reading the deposition. But if I called someone her when I should have called that person him, if I said October 26th of 2017 when I meant October 26th of 2018, if I did something like that, if I misspelled somebody's name by giving the testimony, those types of things can all be cured by reading the deposition. And so I can do it that way. Or I can waive the right to read the deposition and basically just let it fly. Whatever I said, I said. So a couple things to remember about depositions and discovery. Don't answer more than what you've been asked. If they ask you a yes or no question, you answer yes or no. You don't expand on it unless they want you to expand on it. And part of the reason that is because you may say something that you think is innocent or that you think is defending your position, but it actually maybe gets you into more trouble. I've seen plenty of situations where somebody testifies about something and then they keep going. And the trustee or the person taking the testimony says, oh, well, since we've gone down that path, let's continue to talk about that. And I think that also applies when you're doing a bankruptcy meeting of creditors, a Section 341 meeting of creditors. Don't answer more than what the trustee asks. You don't want to lie to the trustee. You don't want to hide facts from the trustee, but you don't have to expand on what the trustee asks you. If the trustee wants you to expand, the trustee will say, will you please explain that? Will you please expand on that? Will you please tell me more? Or I think this or that. But you don't have to volunteer information unless you know that by failing to volunteer that information, you will be committing perjury. In other words, you will be lying by omission. If you think it's that serious that you'll be lying by omission, then you can always take a break, either in the testimony, in the deposition, in the meeting of creditors. You can take a break, ask to talk to your attorney, give the information to your attorney, and then take that attorney's advice as to whether you should expand on that particular question or comment. There's nothing to be nervous about. If you're telling the truth, then there's nothing to remember. There's nothing to be nervous about. You're just simply talking. When you get to those things that you have to write down, the request for admission, the request for production, the interrogatories, go through those with your attorney. Let your attorney take the lead, not to insert your testimony. Make sure that the testimony you're giving is yours and that you're telling the truth. But the attorney can a lot of times frame it or phrase it in such a way that it is true and that you're not, again, giving more than what they're asking for. So there is an art to drafting these things. There is an art to answering these things. I think by and large, if you're telling the truth, you'll be okay. If you have a deposition coming up on a certain issue, or if you need to take someone's deposition on a certain issue and you want to call us and talk to us about some of the do's and don'ts and tips and tricks and strategies, we're happy to consult on those types of issues. So I appreciate you all listening to this week's episode. It's going to be a short episode. I wanted to talk about depositions and discovery because I was the subject of a deposition today, and because I am taking someone's deposition tomorrow. So I thought it'd be an interesting topic for all of you. Remember, we always advise you to tell the truth. If you tell the truth, you don't have to remember very much. You just tell the truth. I do want you to go and visit our sponsor, Elliott Wealth Management Services. Again, they are at elliottwealth.com. They'll give you a free 15-minute life insurance checkup. And if you have any questions for us, you can reach out to us on social media. If you're watching this on YouTube, you can subscribe to the YouTube page. If you're listening to this as a podcast, you can subscribe to the podcast, and then you'll know anytime a new episode comes out, it'll automatically come out in your podcast player on the YouTube channel, however you're listening to this episode. So that will do it for this week's episode, and we look forward to talking to you in next week's episode of the Crushing Debt Podcast. Okay, so we're done Facebook Live. Again, a short video. Yeah, I saw Jim left a comment that discovery is overrated. It can be sometimes. You got to phrase it correctly. If you don't phrase it correctly and the other side gives an answer that doesn't make any sense, that's on the person that's trying to obtain the discovery. So, but other than that, doesn't look like anybody's popped on. It doesn't look like anybody has any questions for me. So that will do it for this week's Facebook Live episode. This podcast episode will probably be coming out in a couple of weeks. And when it does, I'll post this video up to YouTube. But that's it for this week. And thank you all for your listening. And thank you all for your support of the podcast and the law firm. And I'll talk to you next time I go live. Thanks, guys.